Limitations in copyright-free use of public domains. 1. Importance. Article 24 bis of the Korean copyright law states that works that the state or local governments prepared as part of official duties and announced publicly, or works in which they hold the whole of author's property right according to contract, may be utilized without permission. The article was added during the partial revision of the Copyright Law on 2013 Act No. 12137 of December 30, 2013, enforced on July 1, 2014. There was little importance in claiming copyrights on reports, statistics, and PR materials created by the state or regional governments as they were purposed for the use of the public. However, as it was necessary to expand free use on other types of works created through taxes, the revision was conducted on 2013 to follow the international trends in expanding free use of public domains, and to allow the public domains to become a basis of new creations. 2. Requisites. Say works that the state or local governments prepared as part of official duties and announced publicly, or works in which they hold the whole of author's property right according to contract, as Article 9 allows the state and regional governments to become authors of works. Moral and property rights can be allotted to both the state and regional governments. Examples of works authored by the state and regional governments are annual publications and reports. Conversely, the phrase "the possession of property rights by the state and regional government" refers to the complete ownership of property rights. Partial ownership of property rights, such as only having reproduction rights, would be insufficient in establishing a work as a public domain. Use of works that fulfill the requisites stated in this article can be used for translation, arrangement, and adaptation. Article 36 Section 1, as long as the user would indicate the source of the work. Article 37. B. Limitations in free use. Limitations exist in the free use of public domains, and such limitations can be found in subparagraphs 1 to 4, which state the following. 1. Works including information related to national security. 2. Works including personal privacy and business secrets. 3. Works including information whose disclosure is limited by other laws. And 4. Works that are managed as state properties under the State Property Act or the Common Property and Goods Management Act. After being registered in the Korea Copyright Commission under Article 112. C. The use of other public domains. For Article 24 bis to be applicable, the work must be authored by the state or regional government, and therefore, works authored or possessed by public institutions under Article 9 of the Act on Management of Public Institutions are not accepted as public domains, even though the amount of usable works would increase if public institutions were to be included. The Korean copyright law excludes them due to the concerns of increasing unclear usage caused by the vagueness of the concept public institutions, and the complexity in determining the author of work. However, due to the fact that works of public institutions are equally important to that of works of state and regional governments, Article 24 bis Section 2 states that the state may establish and execute a policy to invigorate the use of government works as prescribed by the presidential decree, in order to promote the use of either the works that public institutions under Article 4 of the Act on the Management of Public Institutions created and made public as part of their official duties, or the works in which they hold the whole of author's property right according to contract. In addition to such regulations, the Korean copyright law also includes Section 3, which states that where the state or local governments recognize any of the government works under subparagraph 4 of paragraph 1 hereof as necessary for free use, they may make such works available as prescribed by the presidential decree, notwithstanding the State Property Act or the Common Property and Goods Management Act. The article allows the free use of state property registered at the Korean Copyright Commission. Article 1 Section 2 of the Enforcement Decree materializes the free use of state property through utilizing the indication standards set by Minister of Culture. Sports and Tourism Classification System of the Korean Open Government License. Regarding the scope of free use, although some legislation exists in only allowing reproduction. Unlike the Japanese copyright law, most legislation in Korea allows the broad use of the public domains. No limitations are set in the use of public domains and is shown in Article 36, Section 1. Users of the public domains are able to translate, modify, and adapt these works into their creations. The Japanese and German copyright law limits free use of public domains by only allowing the use of PR materials. The American copyright law similarly limits free use by only allowing the use of works made for hire. However, the Korean copyright law does not add such limits due to the fact that the revisions were conducted for purpose of allowing public domains to become a basis of new creations. However, it should be noted that even if the state and regional government possess the full property rights of the work, moral rights may be allotted to a different individual. And as the article does not affect the effects of the moral rights, the use of such works may require the permission of the work's author.